Morning, everyone. This is the meeting for Wednesday, March 16th of the PZA committee. And could we get a roll call, please, Kelly? No, two. Oh, sorry.
Mr. Featherly?
Here.
Mr. Miller? Here. Mr. Tholen? Mr. Payton? Ms. Peters? Present. Mr. Fairfield? Present. Mr. Snipes? Mr. Swanson? Mr. Dunnell? Mr. Eckhoff? Present. Mr. Kirkstra? Present. Ms. Bryan? Mr. Collins? Ms. Hudson? Present. Mr. Alexander Hildebrand? Mr. Gowler? Mr. Wheeler? Present. Mr. Seroy? We do not have a quorum.
Yep. Thank you. We do now.
Mr. Snipes?
Present.
We have a quorum.
All right, we have a quorum. Okay, proceed as normal here. Okay, do we have any public comment? I wasn't notified of any. Does anyone have any public comment? I don't see anyone here for that. Okay, so I'd like to ask for approval of the minutes. Has everybody had a chance to look through them? And anybody want to make any deletions or changes? Otherwise, I'll entertain a motion to approve them. Okay, Ms. Hudson, get a second. Oh, Mr. Fairfield. All in favor, say aye. Aye. Thank you. Okay. Next up is the building report, February 2022. Del?
You should have this in your packet. For February of 2022, we issued 34 permits with a valuation of $743,000 and brought in revenue of $10,861. That's a little lower than the February of 2021, where we brought in revenue of $12,700.
Okay. Okay, we need a motion to approve that. Then go ahead and approve the billing report. Okay, Mr. Eckhoff, back there, Mr. Kirkstra, second. All in favor, say aye. Aye. Okay, thank you. Next up, zoning process. Del's going to update everybody. We have some zoning things coming in. He wants to make sure everybody has the process, understands the process pretty good.
We have some complicated zoning cases coming up on the near horizon, and Chairman Wheeler thought it would be a good idea to go over the process once again to make sure everyone's on the same page. So the zoning request process, Kelly, is a 5-part process. This is initiated when a change in zoning or a change to the ordinance is warranted. 5-part process. Part 1 is application for zoning action. That's where the property owner or project owner applies for the zoning action and tells us what they would like to do. Second part is notice of surrounding property, and we're going to go into more detail on each of these. And then there's a 3-meeting process, and each one of these boards or committees has a specific role in this process. So it's the zoning board, the planning and zoning and agricultural committee, this committee, and the county board. And we're going to go over those here in a moment. If you don't mind, Mr. Chairman, we could take questions as we go.
Is that better? You want to take each topic and then have questions right after it?
I don't.
Okay.
Either way.
Okay. If anybody has any questions as we go, we'll go ahead and take them as we go instead of trying to remember what they are at the end. Okay.
Okay. The application. When we receive an application in our office, we're looking for certain things to make sure that they are there as required by law. One is the property owner and the applicant, if different than the property owner, must sign the application. Must contain a legal description of the property. Must include a description of the needed action. Must include answers to the findings of fact. Those change depending on the action requested. And other information that may be required depending on the action. They apply for the zoning action. Staff has 5 days to review the application for completeness, and that's what we're looking for is by completeness are those items. We're not looking for what actual answers are given or the content, just that the application is complete. Once we've declared it to be complete, we schedule a case for the next Zoning Board of Appeals to host a public hearing. At that time, we also generate a staff report, and this report gives the pertinent aspects of the case as well as the staff's opinion as to how it complies or meets with the various ordinances in the comprehensive plan of the county and or municipalities if it's close to a municipality. And it will also include suggested information the ZBA should be requesting that may not have been included in the application. In the case of a special use permit, staff would also usually recommend conditions that they feel would be helpful to mitigate any detrimental effects. Okay. Types of zoning.
Del, I had a quick question. That 5 days, is that part of the new law that they're changing to with the state
No,
law?
it's always been there.
Okay, same,
It's
5
always
days.
been there. We have 5 days before, to review an application before we declare it
Okay, thanks.
actually filed. Okay?
Yes.
Types of zoning actions. These are the types of requests that you might see. Map amendment, commonly referred to as rezoning. This is when a property owner would like to change the zoning, the physical zoning of their property, say from residential to commercial, or industrial or agricultural to rural estate. That is actually called a map amendment. That is a legislative action. We'll get to those much later, because that doesn't make a difference when it comes to communications. Text amendment, when someone would like to change our ordinance. That is another action that you would look at. Typically, those are sponsored by a county board member, and we usually bring them before this committee before we start the process. Special use permit, that doesn't change the zoning of a property, but because of the project's nature, it may require special permission due to mitigating factors. A variance, that's when a project doesn't meet the bulk requirements of our ordinance, such as setbacks, lot width, building height. That's when a variance would be warranted. And appeals from administrative decisions and planned unit developments. Planned unit developments in our ordinance are actually a special use permit and follow that process. Appeals from administrative decisions occur when a citizen does not agree with the decision that my department has made and would like it to be reviewed by a committee. It's only happened about twice while I've been here, but it does happen. They all follow a similar process, but there are some differences. Next one, notice. When it's time to do the notices, 15 days prior to the public hearing, both a notice in the newspaper and a notice to all adjoining property owners and any municipalities within 1.5 miles of the site must be notified. The notices to the adjoining property owners and the municipalities must be certified mail, and we must have proof that they were distributed. This is what we call a fatal flaw, because if these notices are not properly done, the public hearing cannot occur, and we start over. Next.
I got, Mr. Snipes has a question real quick.
Can you clarify for me the difference between permissive use and versus the permissive building use in the respective zoning district?
I'm not sure I follow the question.
If there's, what would be the difference between if one has a permissive use versus a permissive building use? I read that through allow you all adopt these codes, and it says permissive use, then it says permissive building use in a zoning district.
I think they're one and the same. Each zoning district has a list of permitted uses. These are uses that you are allowed by right to do in that district, be it on the land or a building, so I think that's the same thing.
Oh, okay, so it doesn't necessarily have to have a building. It can just be a structure, or
Well,
if it's permitted.
a structure is a building, so I don't.
Well, some of them they say in the structure could be, because when they define building, there are some things that are attached, some things are not attached, and yet they still say that that's a building for the purpose of zoning.
Yeah, I mean, a building is a structure. A structure, I guess, is not necessarily a building, because a cell tower is a structure, but not a building.
Doesn't matter.
So the ordinance lays out what you can use that land for, what you can construct on that land. So in a commercial district, you can build a store. Industrial district, you can build a factory. It also tells you how you can use that building. You cannot build a factory in the industrial district and then use it as a house. It must be used as a factory. So it's all listed in the permitted uses. Each district also has a list of special uses. Okay, so if it's on the permitted use list, you can do it by right. If it's on the special use permit list, then you have to ask permission to do it. If it's on neither list, you need to rezone to a district that does allow it.
And I wanted that to make sure, because when people ask me those questions, I figured that now they can refer back to this video.
So how you use the building is directly related to those permitted uses. So if you want to convert a house to a store, then you have to also rezone. And there's also building codes that would have to be upgraded as well. But that's the process you would follow.
Well, they was looking at about if they put a gazebo on their property, you know, versus a shed versus a doghouse. They're saying if that's permitted use.
Well, those are accessory structures. So those are generally permitted in all districts, providing you have the principal use or structure already there. You cannot put up an accessory structure unless you have the principal structure.
So it has
If
to
you
be a
want a
house.
shed, you must have a house or a residence there first.
Okay.
Is that clear?
Yeah.
All right, I think I've covered notices. Zoning Board of Appeals, this is the first stop for any zoning case to be heard. The Zoning Board of Appeals will hold a public hearing to consider the zoning action. This is the time where all information, all testimony, all debate, all discussion occurs. This is where the public can speak its mind, the applicants can speak their mind. It is a public hearing. The planning or the public hearing process, let's go through that. The chairman will open the hearing and declare a quorum. A quorum at the Zoning Board of Appeals is a minimum of 4 of the 7 members. Just a little side note on that, a concurring vote of 4 members is required to make a recommendation. So there must be 4 concurring votes to send a recommendation on to the Planning and Zoning Committee. If that fails, then it goes before the Planning and Zoning Committee without recommendation. So there must be 4 votes, either positive or negative, in order for them to make a recommendation. And if we have all 7 members and they're all seated, that's usually not a problem. It usually becomes a problem when we have less than the whole. We do currently have 7 members now. The case is announced and read into the record. A determination is made as to whether the notice requirements were met. Then the chair asks the applicants to come forward and they state their case and explain what they're doing and why they need to do it. At this time, they present any documents and maps or exhibits, photographs that they feel will help their case. The board may ask questions during this time. Sometimes they wait till the end. Next one. Once the applicants complete their plea, then the chairman opens it up for the public to present any evidence, comments, or information that they have. The board may also ask questions of the public. Upon completion of the public comment period, the applicant is given time to respond to any issues that came up during that. They are not obligated to respond to the public, but they are obligated to respond to the board. So generally, if they don't want to respond to a particular question, the board will ask the same question. Once that is completed, and sometimes that does go back and forth for a while and debated. Once that's done, the board will close the deliberations, or we'll close the public hearing, and then they will go into deliberations where they discuss the aspects of the case, the findings of fact, and determine what their recommendation would be. This is also the time where they would build the findings of fact. Generally, well, not generally, at all times, there's a list of findings of fact for each one of these actions, and the applicant must give their answers as to how their project meets those findings of fact. And then the zoning board will discuss whether they agree or do not agree and how they should be changed when it comes to the findings. At that time, they will make a recommendation to either approve or deny the action, and a vote is taken, and then the hearing is adjourned. After that, staff will create the finding of fact report, which is based on the findings that were discussed by the zoning board. Why do we create findings? Findings of fact is the basis that determines the justification for why the board made the decision that it made. Each action does have its own set of findings that must be considered. They are different for a special use permit than a rezoning or a variance. Variances only have 4, special use permits have 6. Map amendments, rezonings, text amendments have anywhere from 9 to 11 depending on which kind of action you're taking. The decision of the zoning board must be based on these facts. Well, and all boards really must be based on those facts that are presented at the public hearing. Information gathered outside the hearing process should not be considered or used. You got to think of this as a court case, and the board is the judge and jury. The courts don't allow the judges and jury to run around the county asking for more information. They base their decision on the information presented. This is very similar. And the public hearing is the only time new evidence can be presented. Not at the Planning and Zoning Committee, not at the county board meetings. They must be developed for each case, and they must be supported. The findings of fact must be supported by the facts of the case. And it's based on a preponderance of the evidence, which is the facts, not on opinions, speculation, personalities, emotions, or feelings. Those have no place in this process.
Yes, Mr. Wheeler.
Thanks. I've seen this quite a few times as going through some of these contentious cases where in public comment things are presented as facts and without substantiation and things that were not entered into evidence in ZBA. How do you, or how do we police that? Is that an internal conversation you have in your head saying, well, that's not evidence, that's public comment? Do you see where I'm going with this? It has the ability to taint the pool, if you will, of information.
We have two things at odds here. One, the need to limit the decision to the record of the case, which is the public hearing, and the requirement for planning and zoning and county board to have public comment.
Right.
That is at odds with each other. We've never came up with a good solution to that. My recommendation to the board members is to take that into consideration, that public comment at those subsequent meetings is just that. It's not substantiated, it's not supported by evidence, and you should not use that information in your decision-making process. But each person's different and they'll handle it their own way. I can't control that.
Right.
I know some counties, some municipalities hold public comment to the end of the meeting so that it doesn't affect a case.
Huh. Okay.
So,
Interesting.
while
That's
you
an
have to have
interesting
public
concept there.
comment, I don't think there's a requirement that it be at the beginning of a meeting.
There is no requirement. You know, it would be us changing something that people have come to expect.
Yeah.
So we'd have to really think hard about that.
And that would only need to occur at a meeting where a zoning case is being considered, so.
Right.
I really think that would create a lot of,
So do
if
I.
you change it, it would
Right.
create a lot of problems.
I would
I
agree.
have seen that happen. I've seen it happen in this room where the zoning board recommended approval. The evidence and the facts warranted an approval, but because of objectors speaking at public comment, the last thing the board heard was that they went against the zoning board in the recommendation. I have seen that.
It's like if somebody comes into PZA, we're limited to 15 minutes, right? At the PZA level too?
Yeah, what's,
Yeah.
yeah, that's the
So
county code.
somebody couldn't come in and start rattling off a bunch of facts and new stuff
No.
towards the case, and if you do, you can't consider it at all. We really should just let them say it, and then that's it.
And we've typically extended that 15 minutes
Yeah.
many, many times, so. So you should not consider anything but the record itself. You're giving a staff report, the findings of fact report, and any other pertinent information in your packets, and that's what you should be reviewing to base your decision on. Okay.
How about if, Del, if you have something like a solar farm you're looking at approving, and you do a little research on solar farms on your own at home on a computer, is that wrong to do?
We'll get to that in a few slides ahead.
Okay.
But,
All right,
okay,
just checking.
depends on how you use that information, I believe, but it could be.
Okay.
Okay. Yeah, we're up to here. Okay. This just talks about, I think I've already covered this. The findings have been generated by case law. These are not questions that we just randomly came up with over the years since zoning was enacted in 1925. There's been various court cases, and one of the big ones that started the findings of fact was the LaSalle. They used to be called LaSalle factors, which was the State Bank of LaSalle versus, I think, Cook County, which the judge in that particular case said that the zoning board had to base their recommendation on facts of the case, and that's where, and the judge gave 6, I think it was 6 at that time, specific questions that should be answered for a case. They've been expanded over the years, but that's where findings come from. And they are different depending on the action. Now, when it comes to findings, those are the standards that the county has set. The case must meet all of those standards. If there's 4 findings, you must be able to say yes to all 4 findings. If you can only say yes to 3 of them, you should deny the case. If one of them is not acceptable, then the case should be denied. So they must meet all of the findings. And it is the applicant's burden of proof to prove that they meet those findings. Okay? And the board or its members should never attempt to prove or disprove a case or testify on behalf of either side. So this kind of comes to your point, and I'll get a little bit more detail on that in a minute, of doing your own research. Depends on how you do that. The Planning and Zoning Committee, that would be this committee. Your role in this process is not to gather facts, not to hear the evidence, but to review the evidence. Your role is to review what happened at Zoning Board of Appeals, review their findings, and decide whether you agree or disagree with those. If you agree with them, you should make a recommendation or you should make a motion to recommend accepting the PZA's recommendation and forward it to the county board. If you disagree with the Zoning Board of Appeals, then you need to specifically develop findings of fact that shows that this is why we disagree. It did not meet this particular finding of fact, or any of them, but you have to write those yourself, okay? And the third option would be to send it back to Zoning Board, but it should only be sent back to Zoning Board if you don't feel that the Zoning Board gathered enough information or asked the right questions. Not just because you want to delay it, but because there's not enough evidence for you to agree with their recommendation.
Sure.
Question.
Mr.
When we send it back, is it just a nebulous, there's not enough information, or do we send it back saying we need more information on X, Y, and Z?
It should be specific like that. It doesn't always happen. It seems to me, I get the feeling many times the board wants to, because it's a contentious case, they want to send it back just to delay it or to avoid making a decision, but you never avoid it. It always comes back.
Yeah.
But you should, if, let's say you think that this particular project's going to create too much traffic on the road, you would send it back to the zoning board so that the applicant would maybe have to produce a traffic study. That would be a specific item that was not addressed before.
I see.
That would be a good example of why you would send it back.
So our own independent research to learn about a topic could tell us what kind of evidence we need in order to make that decision.
And that's where you could do your own research there.
Yeah.
It's how you use that research where it makes a difference. You are the decision maker, so you should not be testifying for the applicant or the objectors. So presenting that information and how you present it, you could be testifying. If you feel the need to testify on a case, then you should recuse yourself from the board and not be a decision maker, and then you should attend the public hearing and testify.
Yep.
Okay.
The one question I had one time, Del, is we talk about information and questions and write information pertinent to the questions. and we don't think we had enough of it or whatever, we really don't get transcripts of, you give us kind of like a highlight. Does that count as our findings, or do we need to write our own findings for different kinds of cases for the PZA?
Generally, between the time it gets from the zoning board to the PZA, the transcripts are not available.
Yeah.
Now, you can delay a case if you think you need to read the transcripts. Okay. You can certainly, believe the terminology would be table a case. Table it, would that be correct?
Can you send it back on the information that you give on the paper?
There would be no reason to send it back to just because you don't have the
No, I meant
the transcripts, because they will be available. So you're not adding anything to the transcripts. You're just waiting for them to appear. To expedite things, we generally don't wait for the transcripts. We can, but that's probably going to delay every case by a month or maybe 2.
Okay.
Sometimes, though, you do need to read the transcripts. Part of my presentation is to try to tell you what happened at the meeting. But if you want specific information and you want to read the transcripts, then you would have to delay the case until those are available.
Okay. Okay, Mr. Snipes.
Somewhat, I'm drawing a conclusion because you cited a case that's 68 years old, and it's a Supreme Court case, so there's no current case after that, so that's like the rule of law. Before I go further, because there's one sentence in here that I would like clarify, because basically it's telling me from reading this case that every case is subjective because it has its own set of variables. And so with that being the case, if you are sitting in our seats as the trier of facts or whatever you say in the hearing, then that means that it will be incumbent upon us to have had some type of constructive research in the respective area of what we have done in the past, maybe looking at the different variables that might exist, along with taking information from you, as well as I guess how the board has ruled in the past, taking all that into consideration, given that specific area, because that area in maybe Pembroke is different in Herscher, if I'm understanding it right.
I think the answer to your question is yes. Each case is different. The courts recognize that and that's why the findings are general questions that should be answered for each case. It's how they're answered, and that is where it's on a case-by-case basis. You're correct. What's going on in Pembroke may be entirely different than Herscher. Each property is unique. Each has its own set of issues, size. Each one's unique, and each case needs to be considered on its own merits. Now, determining what the county may have done in the past in a similar case is good. Okay, if you typically have been approving a case similar to that, then you probably should approve this one, unless there are
some other variables.
There are situations regarding this case that makes it unique. Yes, you should.
Okay.
Okay, so I think the answer to your question is yes, and yes, there have been additional court cases. That was the one that started the findings of fact, was the LaSalle case.
Okay.
After that, like I said, they've been refined. That's why we have 9 for some of our cases, not just 6 anymore. Yeah,
Okay.
They have been refined over time.
Okay, Dale. There you go.
Okay, so everyone's understanding that PZA is a review committee in this regard, not a fact-finding committee. Okay. Then, presuming they forward it to the county board and did not send it back to the zoning board, the county board reviews the findings of fact, so they review and the recommendation of both the zoning board and the planning and zoning committee, and the county board's job is to make a final decision.
Okay.
County board is the decision makers.
Mr. Wheeler had a question.
Oh, I'm sorry.
It was just hopefully quick. When I first got on the board, there were PZA members and county board members that were going to the ZBA hearings and sometimes testifying themselves for or against. That has stopped, obviously.
That should never happen, yes.
But do you recommend, or is it anything wrong with going and sitting and listening to the evidence
No.
yourself in the
No,
crowd?
because it's the same information that's on the record.
Right.
So you're getting it personally rather than reading the transcript, as long as you don't participate.
Right.
If you participate, then you become a witness, and then you'd have to recuse yourself later.
Exactly. Because sometimes what I'm getting at is if you want to see the transcript each time, your opportunity is to go sit in the crowd and watch it.
And some of this is getting into legal aspects, and I know Terry's in the room, so if you have anything to add to any of this, feel free. But you cannot be a judge and a witness at the same time.
No, I had a problem with that.
Okay, you cannot.
Yeah.
So if you feel the need, if it's in your district and you're very passionate about it, and you have information that the board should base its decision on, by all means testify at the hearing. But then you can't vote on it later. So you have to, each individual member has to make that decision as which one they want to do. Okay. So, county board, they can agree with the recommendation and approve the case or deny it as whatever the recommendation states. If they disagree with the zoning board or PZA or both, just like the planning and zoning committee, they must make their own findings of fact. They can still do that at the county board level. Or they can send it back to zoning board again if the county board as a whole does not feel they did enough, gathered enough information. Okay? Not necessarily just because you didn't agree with their decision. If you don't agree with their decision, you need to state why. Okay? How can I make good decisions?
Okay, Mr. Snipes,
Okay.
is that a hand up?
One other, because I noticed that it looks like it stops at the county board, but do they have yet another remedy for court
It would
review?
go into court.
Right.
After that, county board is the final decision maker at this level.
Okay, then it goes into the courts for under the kind of
Or administrative review, I
Due
believe
process.
is that the correct term for it? Generally, when it gets to the courts are only reviewing it based on the evidence in the record, just like the county board in planning and zoning should be. So there's no opportunity to introduce new evidence or new information.
So do we inform them that of the county at the level of the county board once they get that decision that there is yet another appeal right?
Not normally, no. If they call and ask, what can I do? Then we would tell them they need to seek legal advice.
Okay. Ready to tell?
Okay, how can I make good decisions? You can certainly visit a site. You can drive by it, and I would recommend you do so you can see just how it fits into the context of everything around it and kind of visualize what they're trying to do there. However, while you're doing that, and I've had it happen when I go out and visit sites, either the property owner or a neighbor will come out and start talking to you, want to know why you're there. You should not talk to them.
It's their property.
You can tell them what you're doing, but you should not be answering questions. You should not be asking questions of them, because that comes into ex parte communications. So you just tell them what you're doing, and if they have a problem with that, you can always leave and come back later, but you should not talk to them while you're out there, because you may hear information that was not presented at the hearing. Okay? You should review the application. We create a staff report. We create a findings of fact report. Most of the and the application, between those three documents, should give you just about all the information you need. The only fourth one would be the actual transcripts and or exhibits that would be included. Most of the exhibits do come in the staff report or the findings of fact case. So you should review those. Those will give you all the information about that you should need to make a decision on that case. Ask questions. If you need clarification on a topic, please ask during these meetings. But you do need to keep in mind that at the PZA and county board level, the only questions that can be answered is how they pertain to the evidence as presented. If it gets into the realm of where it would be presenting new evidence, that's where it would need to go back to zoning board for that evidence to be presented. The thing with it's a public hearing at the zoning board, and that's where it gets debated. Both sides get to discuss, get to debate the situation. At planning and zoning and county board, both sides do not get to, so that's not fair to either side, depending on the situation.
Okay, Mr. Wheeler.
Real quick, if somebody submits one of those big poster boards, you see those for the larger projects, and it's discussed in ZBA, comes here and then we ask for some clarification about one part of that piece of evidence that wasn't discussed in ZBA. So like, let's just say, hey, over here, you know, what's this going on over here? And if they didn't ask that in ZBA, because it's already evidence at that point, it's been introduced and we're looking for clarification.
I think you're okay there because that entire poster board as a whole was presented as evidence.
Okay.
Just because a particular part of it was not discussed, it's still evidence, and I think it opens the door for all of it to be discussed.
Okay, thanks.
Does it have to be marked as an exhibit, though?
Depending on the question, I may not be able, because if they did not give me an answer to that question in zoning board, I cannot give you an answer at PZA.
Okay.
So what's going on with these trucks over here? They didn't say.
Well, the applicant is sometimes in the room, correct?
Yes. If it's a clarifying question, yeah, and that's where it gets a little tricky.
Okay.
Clarifying questions are okay. Questions that would produce new evidence, no.
Okay.
Okay, I think we covered that. Let's go on to, what should I not do? Well, ex parte communications is a big one. While a case is active, and that means once an application has been received, has been filed, but before a decision has been made, it's an active case. A board member that has to make a decision on any three of these boards should not be discussing any aspect of that case with anyone outside of the public hearing or the public meeting. Okay? Should not do it. So if you visit the site, you should not talk to anybody. If a constituent calls you up to tell you about it or tell you their feelings, you should tell them to please bring those concerns to the meeting so that all members can hear those same concerns. Okay? Ex parte communication literally means one-sided. It's a one-sided conversation. You may be making your decision on information that none of the other 27 board members has. And you should all make your decisions on the same information as a whole. The only exceptions to that, if you need clarification on something, you can talk to me or you can talk to counsel, state's attorney's office.
Okay. Mr. Snipes.
I'm looking, you should recuse, is that the recuse, R-E-C-U-S-E? Is that just,
I believe that is a typo there.
oh, okay.
Okay. I think we already covered this, but you should not testify for either side of a case. If you feel the need to, you should do that at public hearing, not at planning and zoning, not at county board. I have seen where board members make statements that kind of indicate outside knowledge of the topic that gets very close to being considered evidence or testimony, and if you feel the need to do that, it should be at the public hearing. If you find out that you have that need when it gets to planning and zoning or county board, you should send it back to zoning board so that you can state your case there. There's nothing wrong with any board member being a witness, but they can't be, like I said, they can't be the witness and the judge at the same time.
Okay. Mr. Snipes.
We're walking that same fine line because I do know that if judges are sitting, if they have history, kind of thing like what you basically forestated, if the county has in the past approved these findings, they can use existing findings in order to make their decision. So that information would be okay in that regard because they're basing it off of historical facts of the past without it, you're saying, coming from the outside. Outside information would be hearing other individuals and things of this nature. So there's like a tread of water there when you're saying.
It's situational. It can be situational, and what we also stated that each case is unique. So what happened in the past may not pertain to this case, even if it is a similar case. So you have to use your own judgment on some of that. Okay. There's a difference between using outside information that you know, such as facts of case history, versus actually going out and talking to people and gathering new information. That isn't, first of all, the case history is available to all board members. All of them can look it up. So there is the availability for them to do that. A conversation between you and a neighboring objector only you have access to that conversation. So that's different. Okay? And you should not base your decision on anything other than the facts as they were presented. So if that information wasn't presented, send it back so that you can get it presented. I have seen it before where the number of people in attendance, picket signs, and protests have had a bearing on the decision, and they never should. 50 people not liking a case doesn't make it wrong. It should be based on the use of the land and how it fits into the context of its surroundings. So, but yeah, chants, I've seen them chanting, I've seen signs, I've seen protests, I've seen people crying and emotions. None of that should be part of your decision. But we're also all human. Okay, ex parte communications literally means one-sided. This occurs when information is communicated between parties in a legal proceeding that is not heard by or available to all parties. Kind of goes back to your statement earlier, Mr. Snipes. The previous record of cases is available to all parties. So you could use that. And there is ways to make ex parte communications actually normal communications. So if you have some knowledge that's not testimony or evidence, if you tell the rest of the board that knowledge, now everyone knows it. Okay, so you can use that as long as everyone knows it. A lot of times you might get something in the mail, or you might get a phone call, and before you realize that, hey, this might be ex parte communications, you can't unopen an envelope, you can't unread the letter, and they might say something on the phone before you tell them, I'm sorry, you need to bring that to the case. How can you change that from ex parte communications? Tell the board when you get here at the meeting. Then everybody knows this person called me at this date and this is what they said. I open that letter, bring the letter, we'll make copies of it and distribute it to everybody. Then everybody is aware of the situation. So that's no longer ex parte communications. Okay? And I tell you, looking at case law, ex parte communications can certainly get a case overturned in the courts. So it's very, very important that we not participate in that type of activity. I already covered it. Sometimes it inadvertently happens. Like I said, you can't unhear something you heard, because even when you're out doing the site visit, if they're shouting it at you as you drive away, you still heard it. Okay. So, all right. So, any questions on ex parte communications? It's a complicated subject. You got to use your best judgment. But the safe thing is, if you think it's ex parte communications, tell the rest of the board it's no longer ex parte communications. Okay. Oh, so I can't talk to my constituents? That depends. Zoning actions actually fall into two different categories: legislative and quasi-judicial. Legislative actions, you can actually gather information on it. You are taking a legislative action, which is a change to the law. Map amendments and text amendments are a change to the law. So when it's a map amendment, rezoning, or a text amendment, yeah, you can talk to people. How do they feel about it? That you can. Quasi-judicial actions, such as a variance or a special use permit or appeal for administrative decisions, those are special, and those are like court actions. You cannot talk to anybody and only use the information at hand. It's honestly best if you just follow the same protocol for all, but if it's a map amendment or a text amendment, you can actually talk to people.
Okay. Mr. Snipes, I'm sorry, Mr. Wheeler.
It's okay.
I just got used to saying Mr. Snipes over and over again, so I slipped.
When I ain't gonna touch that. So when something becomes ex parte is after an application is submitted. You can talk about something that has not been officially applied for. Is that correct?
Correct. If we know a case is coming, we can sit here and talk about it all we want to. You can talk amongst yourselves all you want to. You can talk to
Neighbors,
people in the
whatever
area.
else. Yeah.
It's during that official time of when the application has been filed at the county clerk's office till the final decision is made. That window of time, and it varies depending on the case, at that point, you should not. These rules should be in effect.
Okay, thank you.
Now, keeping in mind too, though, that after a decision is made, you still may want to be careful because you don't know if it's going to go to the courts. And anything you say after that could be used possibly in the courts. So to protect yourselves, you probably shouldn't do too much after that. Anything to follow up on there, Terry? Does that sound correct?
Well, okay, so
Uh-oh. We're in trouble now.
Maybe.
I've actually been sitting back there making notes. So when you're talking about from the time that it has started, the application's been filed, going forward, you can't have these individual conversations. Even beforehand, if you're having discussions and you learn information, you're still putting yourself in a position of having information that if you can't separate, you may need to recuse yourself going forward. If you've developed an opinion that you don't think is going to be swayed after listening to the actual evidence, then you might have to kind of think about it and recuse yourself at the hearing.
It is touchy ground. I know one example is some of these solar farms have been having public informational meetings. If you attend one of those, you may have information that the rest of the board doesn't have.
Yeah.
Right.
The only way you'll know that is if once you get through the public hearing and see what they've stated there. So that it can be a problem. Doesn't have to be, but it could be. Definitely between application and decision, that's definite.
Well, and it kind of goes back to what Andy had said earlier when he was saying that board members can go to the meetings and hear the evidence. The board members that are attending that meeting also, though, has to be aware that if the only thing they consider is the evidence that's in record from that meeting, so that if they come back to the full board, they can't argue public comment that's not part of the official record, even though they had an opportunity to hear it at the meeting. So again, they have to be very careful with the information they're considering.
Right. Although most of our public comment is part of the record,
Okay.
because it does go back and forth and questions are answered, and we do allow them to present
Okay.
contrary evidence in public comment. If they have maps or pictures that show something, we do allow that into the evidence.
So then I guess I would go to, what's the basis for that report? What's the knowledge that that person at public comment has to be able to make the representations that they're making?
Well, that's where the zoning board has to ask them questions. What
Okay.
makes them an expert on this subject? When were those photos taken? Who took them? I know in previous solar cases, people would print out reports off the internet and bring them in as evidence. And we'd start asking them questions. Well, how do you know this? Did you write this report? Is the person who wrote this report here? No. So,
Because that was also my concern when Mr. Featherly was talking about outside research.
right,
Okay.
right. No,
If the board members are doing their own research, how do they know what the source of that research is, the accuracy of those numbers?
yeah, the validity of it. That's why you need to base it on what was presented at the case. And hopefully the zoning board has asked those questions to make it valid evidence.
Hopefully.
Okay.
Yes.
Okay. Ms. Peters.
thank you, Mr. Chairman. And
Get it.
I had one question, but now I have two. So if you go to the meeting, and you have to come right away and say, I went to the meeting and this is what I heard at the meeting, then it's not ex parte anymore.
Correct.
You're quick. Okay.
That is a way to bring ex parte communications into
Right.
public communications.
Okay, so you can go to the meetings because they are informational meetings, so you want to be, knowledgeable. So anyway,
Well.
then the next question, you mentioned that there's some complicated cases coming up. Are they more solar farms? I know a lot of letters have been.
Energy related, yes.
Okay,
I think that's it.
here we go.
You good? Okay. Mr. Snipes.
Just one, because was reading a Supreme Court case here where they were talking about the principal use. A lot of times, this is what happens in the in certain cases, and in this specific, an individual, a house was torn down and the garage was left up, and then the individual. I guess the garage burned down, but they left it, had it cleaned up, and 5 years later they came to put it on there, and they was arguing something about the principal use, and the Supreme Court says the principal use, I guess, is the zoning for that particular area, and then what's allowed in the for the principal use in that area, or the accessory use in those areas will comply to that property that's zoned as an R1. So what's happening is it's like you can get a lot of information that's available for that one area because there is, technically it should be a house up there, but in this case there was no house. That's why I was asking when I'm looking, when they was talking about principal use versus principal building use, what was there a distinction in that principal building use that there had to be a building there, or was it zoned R1 and they can have an accessory? Because some people do get lots and put accessories on them, whatever, and so they're not having to buy another house. So I'm just saying, what is that? How it looks like it can get into a hot mess if it's, if it's not defined.
Well, it is defined, so.
It's defined, but I'm talking about defined as to that it has to have, does it have to have, does the accessory have to have a building versus or if they can already own the building, if they have their particular line, they put up something, would that be
It's an accessory.
I'm not gonna speak to that case because I do not know that case. I've not heard that case, but based on what you stated there, you had a house and a garage. The house burned down, the garage stayed. As soon as the house burnt down and was not rebuilt, that garage became a legal non-conforming garage. That garage is allowed to stay because it's already existing, but it's not allowed to be replaced. Okay, so they could keep the garage, they could use the garage until the garage fell down or burned down or was removed. Once that occurred, they could not replace that garage without having the principal use reestablished, which would be the house. So those rules are in place. That's a very specific situation there, but that's how that would be handled.
Okay, so we have the control to say you can't
If
put
it's a
nothing.
vacant lot, you cannot build an accessory structure without a principal structure. But if one already exists, we have some out there that exist before we had zoning. They're legal non-conforming uses. They're allowed to stay. But you cannot replace them. Legal non-conforming structures are only eligible for maintenance permits, which means you can put a roof on it, put new windows and siding. You can't expand it. You cannot rebuild it.
Unless you get a variance or something.
It's hard to do that one.
That wouldn't be a variance. You cannot get a variance for use.
Yeah.
So that means they can't do
Variances
nothing
are
with their
for
property. It's
bulk
just
regulations. They could build a house, and then they could replace the house, and then they could replace their garage or shed or accessory use. If they don't want to do that, and they only, let's say they have the house next door, and they just got this lot because the house burned down and has garage on it, and they want to use it, they can merge the two properties together. It becomes one property, and now the house on the other property becomes the principal structure for the entire property. Then they can have accessory structures on that other lot because it's one property. So it gets complicated, but there are rules and it is all there.
Cake. Okay, done.
Okay, that's all I have. If there's no questions, that's good.
That's it. Okay.
Yeah, we're at the end.
Okay.
Mr. Fairfield? Sorry.
Do you have this presentation sent to each board member
Sure. Sure.
in an email so they have it?
Actually, it's on YouTube.
Yeah, we can send it to you. No big deal. I don't like to send them out early because I don't want to ruin my thunder. You know?
Yeah, that's all right. That's all right. Just,
Your thunder?
You guys
I
read
didn't
it
hear
ahead
any
of
thunder.
time, then this gets really, really boring, doesn't it?
I didn't hear any thunder. It's more fun when you have a case to discuss and compare to. That's all. When he talks about
Yes.
something, if you got something
then you
particular
can,
to talk
you can put
about.
all of this into context if you have, but you can't do it when on an active case, but I guess we could bring up a older case that's already been decided many years ago and walk through the whole process with that would be, that might be helpful.
I would like to see us write findings here, though, at the PZA.
One thing they do find helpful that the Illinois Association of County Zoning Officials does on occasion is mock hearings, where all the members play a role, from attorney to applicant to board members, and the audience just watches and sees, and they can stop it at any time and ask questions about the process. That's always nice.
Yes, Mr. Wheeler.
I wanted, could you clarify what you just said? You want us to write findings in PZA?
We can write our own findings in PZA if we would like to.
You certainly can.
Yeah.
And we have to if we disagree with the findings out of ZBA.
Right.
Why would you rewrite the findings if we're voting to agree with ZBA's findings?
If we had our own set that was typed on a piece of paper that we used as our findings for A through F or whatever we would have here, and many questions you wanted to ask,
Well, they
then
would have
every
to be
case that would come
established
in.
the meeting, though, is what I'm saying.
Yeah,
So we'd have
sure.
to sit and write our own findings and just say we agree with the other findings that are already on paper.
Yes.
If you agree, there's no reason to
There's
write
no
your
reason
own
to write them
findings.
then.
Yeah, but if you have them, well, never mind. You don't want to be doing it during a meeting trying to write your findings, that's all.
We
Well,
should
that
we
is-
absolutely have to write them if we disagree with
Right.
the finding.
Yes,
And you have to state that with your vote.
Yes.
right.
I
Which
disagree with
finding you
number
disagree
4,
with?
and I think it is injurious to the property owner.
Yes.
Based
that
on
kind of
this evidence.
Right, exactly. So,
Yes.
Yeah.
so everybody really writes their own if they disagree.
Gets a little
Yeah.
in and out there for a while. Okay. Anyone else have anything? Okay. Okay.
I
Del, you have more comments?
One follow-up to that. I don't think you really want to write your own findings for every case, because everyone will have different findings. The board should be moving one set of findings forward.
Okay. Well, we can come up with only 4 if we want to, right? Findings? You don't have to
No.
have all 7 or whatever that you have to have.
Yes, all findings must be in agreement.
Yeah.
So
Okay.
if it's 9, you have to agree with all 9.
Okay. Thanks, Del. Okay, we're gonna move on to old business. I see anybody have any old business to go today? If not, we'll go to new business. Mr. Wilson, you're back there. You have something for us today? Just hanging around? Okay. Thanks for coming. Anyone like to make a motion? Mr. Kirkstra?
Motion, second.
Oh, I'll give it Kimberly Hudson over here. It's got the second. All in favor, say aye. Opposed, same sign.